Hello, my name is Valerie Slater, and I'm the Executive Director of Rise for Youth. I'm also a juvenile justice attorney, and I'm excited to be here with you all today to speak with you about protecting Virginia's youth in the age of marijuana legalization. So, we're going to talk about a couple of things. First of all, we're going to discuss what the law actually says. And then we're going to talk about the potential impact that the law as written is going to have on young people, both in community and in schools. And then we're going to talk about how to move forward from where we are now in a way that is going to protect our children rather than create more opportunities for justice system involvement. So let's go ahead and get started. We'll start again with what does the law actually say? So right now, it says that young people, of course, cannot purchase marijuana, they cannot possess marijuana, they cannot use marijuana. And if indeed a young person is caught in violation of a subsection that enumerates these restrictions, then that child is going to be charged no more than a $25 civil penalty. But most importantly to note is that the court shall treat a child as delinquent if found in violation of one of these code sections. And when we talk about the court treating a child as delinquent, we have to look at exactly what the law says in the code sections that are outlined. So 16.1 278.8, that is the particular statute that we're going to look at because it outlines all of the ways in which a child who has been adjudicated delinquent, how can they be treated. So we'll look at that in a minute. But there's more that the actual law says as it relates to young people. And so we're going to now go over. So anytime a child is caught in possession of using or in possession of or using marijuana, they will be charged that civil penalty of no more than $25, and they will be classified as delinquent as related to the court. But then there is some place in particular that children are found, right? They're at school. They're in school because that is the job of a child, to go to school, get an education, be prepared for a future to come, right? That you are preparing yourself for the employment uh, sector. You're preparing yourself for higher education, and all of that happens in school. And the law, as written, it specifically as it relates to consuming or possessing marijuana products on school property, it says that any person found in violation of this particular section is guilty of a class 2 misdemeanor. And so now, when we put that all together, we've got children on school grounds. And if a child, and let me be clear, I do not, Rise for Youth does not, we do not condone underage possession or use of any substance that is reserved for 21 and older, regardless of what the substance is, or any illegal substance. But what I'm saying is that we've got to be careful in the ways that we are treating children. And so this particular code section, it says that any person does not make a distinction or an exception for children who is in violation of consuming or possessing marijuana on school property is guilty of a class 2 misdemeanor. So when we go back to the code section 16.1 278.8, where it outlines all of the potential ramifications for a child who is deemed delinquent by the court, we'll see where some really problematic issues can come into play. And not only there, not only are we concerned with what the code section says, we've also got to be concerned with a child having a class 2 misdemeanor on their record as it relates to a substance that has now been made legal in our Commonwealth, right? Why is it that we have created a new class of crime for children exclusively? Or for when we talk about possession of marijuana on school property, when we look at who that potentially is going to have an effect on, it's not teachers, it's not school counselors, it's not the administration, it's the children that potentially would come and be in violation of this particular code section. And just reiterating once again, not in support of children possessing or using a substance that has been deemed inappropriate or illegal for them to possess or to use. But I am saying, Rise for Youth is saying that when we take the steps necessary to protect children, it ought not be in such a way that it's going to hem them up in the justice system unnecessarily or create legal ramifications for them that will potentially have long lasting effects. A class 2 misdemeanor for a child. What are the ramifications of that class 2 misdemeanor going to be? Well, first, let's look at what does code section 16.1 278.8, what does it say? That is delinquent juveniles. So if a young person is found delinquent, so these are these are the potentials, right? That young person may be permitted to stay with their parents. They may order parents of that child to participate in the same programming that the child is required to participate in. Order the parent of that young person to participate in programming. It can defer disposition, meaning a matter may be taken under advisement, or that child may be placed on some level of supervision to be once again reviewed by the court at a later date. Let's see. So that child may be placed on probation or other conditions or limitations. That child may be removed from their parents' custody. Um, I mean, so just to be clear, I want you all to know that there are 19 possible ways in which a child may be dealt with under this code section. And we again are talking about a child who is in possession of who has used this substance that has now been made legal in Virginia. This child may receive community service or some other restitution or reparation. The court may transfer legal custody to a relative, a child welfare agency. And I know that all of these things seem so extreme, right? It's saying, why would you take such extreme and drastic measures to address a child in possession of or who has used marijuana? I agree 100%. These are extreme ramifications that can potentially be imposed upon a young person. This is a can of worms that just should not be opened, is the point that I am attempting to make here. Could you imagine a child who has been found using or in possession of marijuana and then finds themselves actually incarcerated? That is one of the potential ramifications listed on in this particular code section. So I'm not going to continue reading them all, but I encourage you. It's code section 16.1 278.8. Go through it. Read all of those potential ramifications to a child. And then ask yourself the question, is this appropriate? And even as the code section says, it says that going back to the legalized marijuana code section, it says that a child, they will not only have that $25 civil penalty, but they will also then have to take a drug treatment, require the accused to enter a substance abuse treatment or education program, or both if available, and that in the opinion of the court best suits the needs of the accused. So that the court is mandating right out of the gate, before the particular circumstances for any child have even been evaluated, that it is a requirement that the child enter substance abuse treatment and or education program, or both. The totality of the circumstances, we need to be able to look at the entirety of any issue as it relates to any person that finds themselves before the court. For this legislation to automatically mandate before understanding what a child, why potentially a child is in possession, or why potentially a child is using marijuana, to mandate substance abuse treatment and education. It is, again, too far reaching. We need to evaluate each instance that comes before any tribunal and not just automatically have a one size fits all. And if we can dial it back even one further, a child that is in possession of, or a child who is using marijuana, is the court, is a court services unit, is the justice system the best place to address the needs of that child to begin with? It seems more appropriate that we would begin and we would want to look at, why would a child, why would someone under the age of 21, and I'm speaking kind of specifically to those under 18, why would a child, a 17-year-old or younger, be in possession of, or be so inclined to use marijuana? I think we would do better to look at all of the issues and circumstances surrounding that child so that we can identify what their needs are. If we are more willing to take a health approach, how are we going to be able to understand what's going on in a child's life, what's going on in a child's mind, what's going on in a child's emotions, and why then is it translating in the use of this substance? And it feels as if, it seems as if it is more appropriate for our health department, for social services, for the services that are in place to provide supports to young people, to their families. They would be better suited to address the needs of a child who is in possession of, or who finds themselves potentially using marijuana. Much more inclined to be better suited to address the needs than the court system. Might the justice system encourage that child, or even mandate that that child then engage with the social services or with the health department to receive services? Absolutely. But if we already know that that's where we're going to be sending a child, why don't we start where the solution begins, rather than involving the court system, where systemically and historically more problems have begun for children? Because once children get involved with the justice system, it becomes much more likely statistically that they will continue to be engaged with the system. Because unfortunately, it's like quicksand. Once in, it's much more difficult to get out. And so let's not create that pathway. Let's not create that involvement prematurely. So, that's what the law says. Those are some of the ramifications. But then when we are looking at school, when we're looking specifically at school, we already have an issue with children of color predominantly being pushed out of school, and the access to education being much more difficult on a consistent basis for children of color. And we already have a problem with our justice system involving children of color more significantly. They becoming children of the In Virginia, we already have an issue where children of color are engaged in our justice system disproportionately to their population in Virginia, even in the school divisions and in which they reside. And so this idea that we will create just one more way for children to have involvement with the justice system is again problematic. Just one more way for children to be removed from the school environment, because each school division already has in place its laws or its policies with regard to marijuana possession, or substances, drug substances on school property. And so now we have created a class two misdemeanor, which would then be within um, that category of offenses that must be reported to law enforcement. And so it has continuously just created this system to push children out of school, make more difficult for them to remain within their educational environment. And then once children are no longer in school, it becomes easier for them not to come back. They fall behind. And depending on what the court is going to mandate for a particular child. Will that school division allow them back, or will this child then have to go to an alternative school? And we should be creating ways for children to remain in school. We should be creating opportunities for children to address their issues that does not also entail them being pushed out or excluded from or shuffled off to alternative education programs. So if we can just take a pause here and consider everything that we have discussed thus far. So we know that the law, as it is written, has created a new level of crime, this class 2 misdemeanor that will apply specifically to children if they indeed have marijuana on school property. Now, if our intent and purposes for this new law is to end the war on drugs as it relates to marijuana, then why is it are we creating this whole new opportunity to hem up, especially children? We don't want the new war on drugs to be against our youngest and our brightest. Um, we don't want to create a system whereby the new war on drugs is against our children. And unfortunately, as this law is written and as it relates to young people in the potential to possess marijuana or to use marijuana on school property, that class 2 misdemeanor, that's exactly what we're doing, or at least we're setting the stage to do. And we cannot. We must amend the law as it exists so that we are able to create environments where children are receiving the assistance they need to come back from the mistakes that they make. If children are using marijuana, we must pay attention more readily to what is causing that use rather than punishing that symptom, right? We don't want to punish behavior. We want to change that behavior. We don't want to address a symptom. We want to understand the problem and solve the problem. And the way we do that is making sure that every young person that ever is found in violation of this particular statute is given the supports they need to come back from that mistake, not a justice system that's purpose is indeed to address criminal behavior. So again, let's take a look. What does the law say? It says that if you are under the age of 21 and you possess marijuana, that you are going to be charged a civil penalty. If you're 18, if you're under the age of 18, that civil penalty $25, and then the mandated drug substance abuse treatment and education, both if it's available and at the discretion of the tribunal. It also says that if indeed you are on school property using or in possession, that you're guilty of a class 2 misdemeanor. So this law in and of itself is creating, and that a child will be deemed delinquent by the court. So while it says it's a civil penalty, if the child is deemed delinquent, the actions that are on the table for a court to take against that child are significant and far-reaching. And again, I know I keep saying it, but I'm going to reiterate once again. We need to be sending children to the appropriate services and not to the court. If a child is caught in possession of, if a child is using marijuana, that is not a symptom of criminal behavior. It is a symptom of a need that needs to be addressed for a child. And that is what we ought to spend our dollars on. That's where our tax dollars should be spent. That's how we should be wrapping around children to help them find a positive way forward rather than criminalizing children and causing them to find themselves embroiled in a system that has just traditionally not been the most helpful way for children to find their way back from their mistakes. So, where do we go from here? How do we address in a more appropriate way? So, again, as the law is written, what we would like to see happen is that we repeal that piece of the law that requires children be found delinquent. That civil penalty, that's fine. But delinquent should not be the way a child is classified. A child in need of services and a child in need of supervision, those are um, other avenues that we have at our disposal to take. And if a child is in need of services or in need of supervision, that's very different than delinquent. And if we have legalized marijuana, then why is it that we are going to be treating children and understand that finding a child delinquent, that is the same as finding an adult guilty. So if for an adult, they are found guilty. For a child, they are found delinquent. If we have legalized this substance and we are recognizing that the need for a child who is in possession of or who is using this substance, if we are understanding that substance abuse treatment and education, if those are the avenues that we want to take, then let's take that avenue fully and find that this is a child who is potentially in need of services or potentially in need of supervision, but put both of those provisions on the table rather than the criminalizing that child by finding them delinquent. That's step one. So removing the delinquency and adding in instead child in need of supervision or child in need of services, and allow that determination to be made based on an evaluation that is done of that child, not just an automatic. See, as the law is written, it also says automatically that a child is going to go to substance abuse, and that child automatically is going to receive that education at the discretion of the court. Well, rather than making an automatic, what we ought to be doing is evaluating that child to determine what the appropriate course of action is. A tribunal is not the appropriate place to determine what a child is in need of. It is the appropriate place to begin that evaluation. However, if we are going to involve the courts, then at that court level, the only thing that court should be deciding is what evaluation agency is available to determine what the needs of that child are. So if we dial it back one more, we would also argue that the court is not the appropriate place to send a child, right? That the court services unit is not the appropriate place. That what we should be doing is that child should automatically be referred for evaluation through an agency that has the expertise in working with children and that has substance abuse use and treatment as that's the work that it does. And so the Department of Behavioral Health, Health and Human Resources, those are the agencies that ought to immediately come into play because we need to evaluate what the needs of the child are. And if they are substance abuse, we have that agency already. If there are other issues, human resources, we have that agency. And so we need to use the appropriate agency to address the needs of a child. And the way to do that, again, evaluation. So what this law, if we were to edit this law, to amend this law so that it appropriately addresses children who are found in possession of or using marijuana, we would, number one, refer that child to the appropriate agency for evaluation. Number two, we would determine what the best course of action forward, what the appropriate services, whether they be substance abuse, whether they be education, or is it that Health and Human Resources are going to get involved, and they are going to address the other needs of a family. Are they going to address the mental health needs of a child? And we don't know. It's going to be on a case by case basis. And so we also ought to make available that a child, once evaluated, may be deemed a child who is in need of services, a child who is in need of supervision. So we need to remove the delinquency. We need to transition who has first contact with that child. And then when we get to the school grounds, it makes sense that you would not want marijuana on school grounds. But as the law is written, it it ought to address adults who are inappropriately bringing this substance onto the school property, and the students, they ought to have that same course forward as any other child in any other circumstance. And so the exception to the code section as it relates to possession of marijuana on school property, it ought to read that the exception to, or if you have possession of this substance on school property, that there is a class 2 misdemeanor, with the exception of students, and then that a student would immediately be referred for evaluation, that student would then, once that package of services, whatever is necessary to support that child, once it is determined that that child will then be mandated to participate in whatever services are appropriate to meet that child's needs. So those are the amendments that we would like to see, that we will advocate to see happen to this law. Because what we don't want to do, if I might just say it one more time, we do not want to criminalize a next generation of Virginians, of young people. And as the law is currently written, unfortunately, we have created the circumstances under which we could indeed be waging another war on drugs, but it would be against our children. A class 2 misdemeanor for children in possession of marijuana, or children who are using marijuana on school grounds. We ought to be asking ourselves why that is so, and how do we address the needs of those young people. We don't want to jump so quickly to punishment, jump so quickly to ramifications that will have such long lasting consequences. Because once a child is deemed delinquent, they are dealt with in a particular way. If they ever find themselves in trouble again, they're dealt with a certain way. This is the potential to get children kicked out of school. We need to make sure that we are not pushing children out, but rather wrapping around and supporting and meeting the needs of every child. School is supposed to be the place for learning. It's a place for learning, both academically, socially, and emotionally. And when a child is struggling in any one of those areas, we don't find the ways to push them out. When they're struggling in any one of those areas and acting out in such a way to mitigate in the best way they know how those struggles, we don't want to punish that child. We want to wrap around that child and provide them the services and the supports necessary for them to become successful in every area of their life. If children are using marijuana, if children are possessing marijuana, we need to address the underlying issues, and not the fact that they have marijuana in their possession, not the fact that they have used it, but what is the problem? What is the underlying circumstances that brought them to this point? And so I just ask each and every one of you to, this General Assembly session, be willing to have this conversation with legislators. Be willing to stand behind the work to amend these laws as they relate to our children, to ensure that we aren't criminalizing kids, to ensure that we are not penalizing kids, to ensure that we are instead supporting and assisting young people to find their way back to a positive track, to a positive path. Because every child deserves the right to dream and to become their best self. And the way we are going to help them do that is to help them overcome every challenge. And if one of the challenges they're facing is leading them towards the use of marijuana, then it's time for us to be supporting adults, supporting the supporting cast to their success. And so, would you go to riseforyouth.org and take a look at our legislative agenda, help and support in all of the ways that that you are willing and are able to make sure that as we move laws forward in Virginia, that they are helping our children, not harming them, and that when we find harm, that we are quick to address it, we are quick to correct it. And in our marijuana legislation right now, there are some ways that we have the potential to do some significant harm to children. So help us change those laws. Do what you can to support every child so that every child does indeed have an opportunity to live their absolute best life, free of justice system involvement, free of charges or any other ramification that may come if they run afoul of this law. Thank you so much, and I would be happy to entertain any questions that anyone might have.